Morning.
Hi everyone. Good morning and welcome. So is everybody here already? If you can hear my voice, you can type in the chat box and type number 1 or just say hi. Hi Annette. And hi Irene, hi Evelyn. Hi Yvonne. Good morning, Queenie. So currently we have 18 participants. So we're going to start very soon. So just give us a few more minutes for preparation. Thank you. So if you have a camera on your computer or laptop, you can switch it on so we can learn together and look at each other's faces lah. Huh? So it'll be more interactive as I can see your reactions and your smiles on your faces. May I ask if everyone can see the slides? If you can see the slides, right, okay. Just type okay in the chat box, just to let us know. All right, so we'll get started right now. Good morning, everyone, once again, and welcome to Lee & Partners Legal Advisory Program. So this program is actually a very special program, and today's session is specially made for y'all because normally we conduct this session in Mandarin. So today's class we made specially in English for y'all, so you guys can learn with us and yeah, okay. So before we start, I just want to introduce myself. My name's Jen. I'm currently doing my internship program at Lee & Partners. So today with me is Miss Nicole Lau, our legal associate who specializes in will and trust. Nicole, can you say hi?
Hi everyone. Hi, good morning.
Hi Nicole. So also before we start, I just want to introduce a little bit of background story of Lee & Partners. So our founder, who is also the managing director, Datuk Lee Lin Fong, founded Lee & Partners 6 years ago in 2014. And our firm has been rewarded by the Malaysian Books of Records with having the first law firm with a charitable coffee shop or cafe. So, and also we were granted the award of the best legal firm in Malaysia by Dewan Economy. Yeah. So Okay, today's session, as I said, is very, very special as it's conducted in English. So if you guys have any questions or any concerns lingering in your mind or anything, you just unmute your mind and ask us questions. Don't hesitate, okay? So we'll get started very soon. So Nicole, I will pass on the mic to Nicole. All right? Okay, enjoy your class.
Hi, good morning, everyone. Hi, can everybody hear me? If can you type 1? I just want to make sure before everything starts. All right, okay. All right. So a very good morning to all participants. I just want to say it's a very special day because for this round we are using English and we are doing sharing. All our sharings are done in Mandarin. So bear with me if I I tend to pause for a little while to think of the terms because usually we use Mandarin, so it's very smooth, and this is the first time, not the first time, the least we seldom use English to share because most of our participants, they prefer the sharing to be done in Mandarin. So bear with us and bear with me if there's there's any terms that or my language is not that smooth. So so I will just start with a little introduction of myself. My name is Nicole. I'm a lawyer here at Lee & Partners, and meantime, I'm also managing our company, which is Lee & Partners Legacy Advisory, doing managing will and trust, and also other services like insurance and also investment and also life planning products. So today I'll be talking mainly on the wills, the will part, and all the legality and also the requirements to to get a will properly drafted. Okay, so I would like to move to the next slide. Okay, before that, I just want to ask our friends in Zoom, who has written their wills. So if you have written your wills, please type yes. If you have not done yet, please type a no. We just want to just want to have a quick view on who has done your will and who has not. Okay, so far I can see only 1 yes and already 4 no's. So yeah, 5. Okay, so out of um out of 10, maybe 2 yes and 8 no's. And that's why we can see that actually many of the society, they are not aware of the importance of writing a will yet, because actually I'm also a lawyer doing estate matters, so I handle a lot of LA cases and also probate cases, so I can really see how really see the problems faced by our clients, like halfway through, then the other family members, they are not agreeable to these terms, how they want to distribute the assets and so on. So there's a lot of hassles and also a lot of hiccups through the process in applying the especially the letters of administration, which is called the LA in short form, because without a will, you have to apply for letters of administration. This I will further explain in the later slides. Okay, so roughly we can see from the feedback and also the replies that from the participants, mostly they you wrote a no. So that's really there's a question that we really need to ponder, because without drafting a proper will, it will lead to many problems in after one passes off. So I think today it's a very I hope that this sharing will really open up your eyes and also your mind to really ponder about this issue, because it's very important, and really a lot of people, they don't know that, oh, actually it's so important to, to just do a simple will. Don't have to be very complicated unless you really have a lot of assets, and also, you have a lot of ways or manner you want to distribute it. Or else just a simple will, like all my assets and so on, but we don't encourage it. Later I will explain further. So very quickly we go into the slides first. Okay, first question, why do we need a will? Okay, why do we need a will? Why is the will so important? Because I'm not very I'm just very young, so my circle of friends, it's a bit hard to ask them, to convince them to write a will, because usually their reply will be, I don't have anything yet, I'm just, I just graduated, I just started working and stuff like that. So usually this will hit those who have families already, like children, and they have elderly parents at home, or grandparents who they need to take care. So usually this class of people, they will really sit down and ponder, oh, I think it's time for me to draw up a will. Okay, so the question is, why do we need a will? Okay, so you can see from this Borneo Post online, this reported news, this red box, it is alarming that a staggering 70 billion unclaimed assets. So you can see that now Malaysia, this China press, sorry, is in Mandarin. Just want to show you that 70 billion unclaimed assets. Everybody, not everybody, most of the people are not aware on the importance of doing proper planning on their estate, and also that's why they don't have the knowledge on doing a proper planning. Hence why there's 70 billion assets unclaimed at the government department. So can you imagine how crazy it is? We say that our former prime minister, 2.6 billion, that's already a lot of money, but this is 70 billion. So can you imagine how many times, that's why it is, most of the people, they are not aware. When they see this, they start thinking, 70 billion. Oh, okay, 2.6 is already a lot. So what more is 70 billion? So that's why we want we want to share this to more people, to help them to do a proper asset planning, to prevent their assets to be part of this 70 billion. Okay, so this is one of the news. Okay, this one from the Star. Many Malaysians still have misconception on writing wills. So this is very true, because based on my experience, when I approach my friends, or my some of my older friends, or even elder people, they don't know, or even my clients, they don't have this awareness. They think that, oh, okay, I thought the government will do it automatically. They will transfer it to my family. I don't have to do anything. I just need to, inform my children that, okay, I'm giving this to you, I'm giving this to you, and such. But then this is really not the case, because you have to write it down black and white to prove that this is your wishes to give any particular assets to anybody. So from this mini box down there, the last paragraph, you can see that 90% of Malaysians, okay, so you can imagine 90% of Malaysians, that is how many people in Malaysia. So the market is very big. If you talk about the sales part, the market is very big and very huge. And also, meantime, it is sad because many Malaysians, they are not aware of this issue. So it's very dangerous, and also especially to the kids. And also, how do they know that actually the assets will be frozen and stuff like that after one passes away? So this is what we really want to share to the public and also the society, so that many more can be aware of this and also start doing that planning. Because actually it's not easy to really sit down, quietly dig out all your documents, and also think of how you want to distribute your assets to who, how much, and such. So actually, during MCO, we have done a lot of live sessions on will and also trust to educate the public and also the society on the importance, because that period was crucial because of MCO, and a lot of people, they are at home. So we encourage them to really use the time, because we have more free time during MCO. So use the time to dig out all your documents and sit down and properly think and manage and also do planning. So because usually people will tell us, I have no time to to really go and search for my documents, have so many things to be done, and I have to really sit down. So MCO was a very good period and also a good timing for families, especially parents, or to really sit down and do planning. So from there, actually we have clients who come to us and say that actually, yeah, you're right, and I really want to do a will, and I also want to do a proper planning to protect my family and also my children. So yeah, so maybe after this, many of you will start having this mindset as well. So I hope that many of you will gain some knowledge on this today. Okay, so next, you see brothers fight over mother's estate. So there's a lot of reported news saying that because of your parents' assets and your family, um, all this happened because of the disease estate. So those, like, we are still parents or whatnot, you are still alive now. So why not you make a proper planning? You do a proper planning to avoid your children or like relatives and so on to to keep eyeing on your estate, or you won't know what will happen like after you left. So why not you do a prevention. Okay, prevention is better than cure. So why not you prevent something worse that will happen, like you prevent your family to fight, your children to fight over your, just because of your estate. So I don't think it's very worth it. So but okay, so next, I can't get money from bank. So this condition is because um this situation is because it is a joint account. So we have not every bank allows, if let's say me and my husband, we have this joint account. So not every bank allows you to withdraw if the other half already passed away. You must see that whether that bank practices this joint tenancy, this policy, this term. Okay, so if they don't practice this term, so basically the other half, they won't get to withdraw the money. Okay, they have to go through probate or LA to withdraw the money from the bank. Okay, so you see, when you don't do, and most of the people, they are not aware of this issue. They thought, joint account, so I can just withdraw lah, when my other half is not around. This is not the case. Okay, if you have any question, you can just list it down first. After the sharing, we will answer. Okay, so because we don't want to we don't want to have we don't want to stop so many times. So if you have any question in your mind, you can just list it down first, and after that we will go through one by one. Okay, all right. So all this from all this reported news, we can actually see that actually, oh, this could happen, which I'm not aware of it. So it's good that we can get this kind of news, because some are really practical, and if we don't get into that and we don't have experience ourselves, we won't know, like, oh, actually this works like that, and this bank, their policy is this. So what, so it's very hard to grasp what the respective bank, what do they have. So it's very wise, and it's very good to just list it down, everything in your will. Okay, regardless your joint account, this I will explain later. Regardless it's joint account, sole account, everything is, if it's under your name, you just put it in the will. Okay, so next, this is in Mandarin, reported in Mandarin. this says that 5 brothers and sisters, they fought over the estate of the parents. So in the end, their relationship broke down, and they took their parents' ashes, and they just treat it as rubbish, and they just throw it away like that. So without any proper planning on the life, the parents' life planning stuff, like going through virtual and also burying them and stuff like that. So because of all these assets, they fought over all the properties and stuff like that. They don't even care about their parents. They just treat it as rubbish, and they just throw away. So it's very ugly, and it's very not appropriate. It shouldn't be this way. Okay, so to avoid, because we wouldn't know like what our children or our next generation will do because of money, because money is a very evil thing. as many of us know, money can cause a lot of troubles, and also just money can cause like fights, cause a broke down relationship, and also stuff like that. So really, to prevent, better we do a proper planning to avoid all this unnecessary stuff. Okay, so next, okay, this says that there's a joint account or joint name on the property. So this mother and daughter, they have this joint account property. So the mother wanted to transfer it equally to all the children, but one of that daughter, which has the joint name with the mother, she refuses. She said, no, I don't want like that. I want it, your portion, you give it solely to me. So that's not the mother's wishes. So how can you do it? How can you distribute it fairly? So the only way is to write it in your will. So regardless, because will is to write down your wishes. So everybody else cannot challenge it, or cannot stop you from doing that, because that's your wishes. Okay, so actually you don't have to really get permission from your beneficiaries, like I want to do this, I want to write my will, but I let you get how much, stuff like that. Actually, it's a P&C document to yourself. It's your own planning. So actually you don't have to be influenced by the others, like okay, how you should actually distribute the assets, like how much you should give it to me, and you should not give it to who and such. So this is actually based on your own sole discretion. Nobody else can actually influence you. Okay, so next, okay, why we said that, why do we need a will? That question, the first question we saw just now. So first, there's no centralized system to trace all your assets. There's no one system in Malaysia that you just type your name, like okay, type Nicole Lau. So whatever assets that I've purchased before this, or I've acquired before this, will pop up in that list. So actually some people, they think that there's confirm there will be this kind of system in Malaysia. The truth is there's no centralized system to trace all your assets. That's why nobody will actually know what you have purchased and what you have acquired during your lifetime. So my question is, how are your family members supposed to to know that what you have purchased previously and what do you own actually? Okay, so it's a very big hassle, because if you don't list it down or you don't write it somewhere else, then your family members wouldn't know, like actually my who my let's say for example my grandfather, we don't know what he has bought, like throughout his lifetime. So that's why we have 70 billion of unclaimed assets, because people, they don't know, they thought like or maybe they have done already, they have done it, they have sold it away or transfer it, or pass it to the trustee. So there's no instruction to instruct like how your assets are to be given away, or how you have planned it to for your assets to maybe you want to sell it off, or you want to pass it to whoever. So remember, there's no centralized system to trace all your assets. Okay, that's why we need a will. So the next one is, there's no automatic transmission of assets to your family members. So like previously I mentioned that, many of the clients, they have this misconception. They think that, oh, actually, government, they will just transfer it to my family members lah. So I don't need to do anything. I just, after I left, then everything will go on smoothly. Then they will get their shares. My wife, my husband, my children, they will get it, automatically, because they are my next of kin, they are my family members, so the government should know. So this is a very wrong conception, because there's no automatic transmission. And also, this transmission of assets and also the application for, LA or probate, they are separate application, and also there are separate fees. So transmission, they are counted, they are charged, their legal fees are different, and also the probate or LA, they are different. So it's separate. It's not, automatic and everything, because, it's very funny lah, like automatic transmission. So who will bear all the legal fees for the memorandum of transfer and such? So that will be a person who has to, bear all this when this kind of transaction is going on. So remember, there's no automatic transmission of assets to the family members. So the first one, just now we mentioned, there's no centralized system. So the second one is no automatic transmission of assets to their family members. Okay. So, okay, so the next question is, what is a will? So we mentioned that we need to write a will. So what is the will? Okay, a will is a legal document stating how assets shall be managed, arranged, or distributed to the beneficiaries after a person's demise. So basically, it's just a document. Then you just state, like, what assets I have, then how to be managed, like, or who I want to give it to, or how, you just instruct somebody, maybe you want to sell it off, or the balance of money and such. So everything you write in the will to inform the executor, to instruct the executor what should be done, and what kind of arrangement you want to have. Okay, so in Malaysia, just now, as we can see from our simple survey, just from our participants, I saw that, only 2 have written, and others wrote a no. So, in Malaysia, 90% of the people are eligible to write a will, but have not written their will. So you can imagine, like, how many people. But I'm pretty sure that, slowly, as time goes by, slowly, people are starting to be aware, like, oh, actually, I need to have this planning done quickly, because we can't predict what will happen tomorrow, and also even the next minute, like, I'm here to now, the next minute I don't know what will happen to me. So everything is unpredictable. So I have few of my friends of my age, I also didn't expect that they will, just meet an accident and also just pass away like that in this age. So, many things we cannot predict. So why we want to say, like, oh, tomorrow lah, or, I'm still young, I don't have anything, I only have like maybe a few thousands of ringgit in my bank, but, like maybe one car, and, I'm renting and stuff like that. So I mean, at this age, we will at least have something like cash, or maybe one car. A car is still a car. So if you don't do planning on the car and also your bank accounts, so it will lead to that 70 billion of unclaimed assets. So why not you make a proper will, and also a very simple will, just to state that, okay, if I'm not around, this car shall be passed to my sister, or my younger brother and such. So at least you won't go through the process of the LA, which will take a very long time just to obtain the grant. This one I will explain later. So just to let you see that, at this moment, Malaysia is still, is still a very huge market lah. So after we learn this, we are up to, I think we are up to share this importance of this estate planning to our friends, and also most importantly our family members, because you know, through if they don't know, they will really meet, you know, they will really go through a lot of troubles and also hassles, like, you know, what if the bank, you know, they enter caveat and this such. There's a lot of problems because I handle probate and LA cases, so I have a lot of case sharing, which I will share it later to you. Okay. So next, what are the main governing laws on wills? So very quickly, this I will just go through. Wills Act, Distribution Act, Inheritance Family Provision Act, Probate and Administration Act, and also Small Estates Distribution Act. This one you don't need to know. I just roughly tell you what are the main governing laws on wills. Okay. So the next question is, why is writing a will so important? Okay. So let's watch this video first.
Meet Matt and Mary Wilson. Matt is a senior executive. Mary is a hospital volunteer. They have 3 kids, a house in the burbs, a condo at the beach, and are saving for retirement. But like 58% of adults in America, Matt and Mary do not have a will. They need one, and here's why. A will is a legal document that defines who is going to take care of your children and outlines what to do with your assets when you're gone. If you die without a will, the state will decide who will inherit what you once owned. A will allows you, not the government, to control your assets after your death. If you're like the Wilsons and need a will, here's what's involved. When you do your will, do it right. Work with a lawyer to make sure your will is structured properly to be valid and enforceable. If your children are minors, name a guardian for your kids. Your trustee will follow the instructions in your will on how you want your assets provided to your children and their guardian. Make a list of all your assets and where they are. Determine the values of your real estate, insurance policies, investments, business ownerships, personal possessions, and anything else that has economic or sentimental value to you or your family. You decide who will receive these assets and when. Typically, your surviving spouse will be your primary beneficiary. You provide instructions on how and when to distribute assets to your children, grandchildren, and the charities of your choice. You appoint an executor or trustee to oversee and carry out your instructions in your will. You can grant the power of attorney to someone you trust to make health care and financial decisions if you are not able to make these decisions yourself. This living will provides a roadmap to your heirs and your doctors on how you wish your health care and end-of-life decisions to be managed. There are so many reasons why wills are important. Work with your trusted advisor and an estate attorney to write your will. Then, update it every 3 years to make sure it fits your present situation and conforms to current state laws. That way, you know your family, your loved ones, and your assets are all protected.
Okay. All right, that's a very simple and straightforward video to show you like why we have to, you know, get our bills done. So, you know, you have to take care of your minor children and also your family members and also your maybe your business, your properties and stuff. So everything will be included into your will. So that's the instrument to, you know, to get your properties, everything, you know, distributed well. So the next reported news is in Mandarin as well. The heading wrote it in the way as, okay, this is regarding some EPF nomination or insurance nomination. So sorry. Oh, sorry. This is regarding a will. This person has already written a will, but you know, he broke up with this girlfriend and also stuff like that. So he actually named the previous girlfriend in the will, and he didn't update the beneficiaries list. You know, after the broke up. So you know, everything goes back to the ex-girlfriend. So you know, you have to act wisely, like when you already broke up or you have divorced or you know you have entered into a new marriage. Usually we will advise you to rewrite your will because the beneficiaries list will be changed. Of course, this is definite. So that's why we will encourage, if you have a major change in your life, like you get married or you get divorced, or you know you have you have newborn babies, or you know you have people who already passed away and stuff like that, you have to do an update of the will. Okay. So the next news is, you know, these two brothers, they fought over the property, and also the backbone was broken because they fought over the estate. So you know, things like that will happen because of money and also because of properties or even assets of the parents. So as parents, I think our duty is not only to, you know, to educate our children, to bring up to be involved in their bringing up. We also have to, you know, do a proper planning for the future to safeguard, you know, all the children's interests. So you know, they won't, because of all this estate and also all this money, they fight unnecessarily. Okay. So very quickly we go into why we need a will. Why will? Okay. Okay. So the first one is you decide how your estate is to be distributed. Like, you know, you can write it in the will, like, okay, maybe this property A, I want to give it to my eldest daughter. My second property, I want to give it to who, then stuff like that. And you can also distribute it, like one property, you can distribute 50% to this daughter, then the other 25 to the other children. You can, it's really, you know, it's up to you to write your will. Okay. And you can have many kinds of arrangement in your will, like, okay, if these children, you know, is the bankrupt and stuff like that, or the beneficiary is the bankrupt, so you know, I won't give my portion to him or her. So there's a lot of ways on how you can distribute your property. Okay. So second, you decide who to execute your estate. So actually this is very important because it's actually very important to appoint that person to be your executor. Why? Because you have to really consider that that person is trustworthy, and also that, you know, he can really do a good job in executing your estate. Because if you appoint somebody who, you know, chincai lah, like no need lah, like so little assets only, what for I want to do it, wasting my time, you know, I need to go and find lawyers and stuff like that. So you really have to think and also to appoint wisely on, you know, who to be this executor. Because once if you really just chincai, you know, just simply appoint, so maybe it will affect your family members, and also, you know, your family won't get what they are supposed to do, but supposed to have. But don't worry, because if the executor is not doing his job, actually other family members, or you know, the beneficiaries, they can appoint, they can go to the court and apply to the court and ask the court, you know, to appoint somebody else who are more capable to do it. Okay. So to save all these hassles, because we write a will to simplify the process, to fasten the process. So we don't want our clients to, you know, write a will, but you know, throughout there's still a lot of hassles, like, oh, executor don't want to do the job, and you know, they are not doing the job well properly and stuff like that. So it amounts to, like, you know, like no will also like that. Oh, then why should I write a will? So everything should be planned and also do it well. Okay, so thirdly, you decide who will take care of your minor children. Okay, most of the people, they don't know, actually they can appoint a guardian in their will. So you just write, you just state in your will, I appoint my sister, my brother. So just to let you know, very briefly first on this guardian, that you can appoint a guardian. After that, we will go deeply, we will go further in, like how, who, or what the guardian should do after, you know, being appointed as a guardian. So the next one is to avoid a lengthy estate administration process. Okay, many people don't know that actually once a person pass away, so their assets will be frozen. So you know, their family members have, if you have no will, you have to find a lawyer, you have to ask the lawyer to apply for this LA, and also not only LA, you have to apply for distribution order as well. So after the distribution order is granted, only you can administer the estate. So it's a very, very long process. It takes up to, you know, I have a client who wanted to apply for LA last year during June. She came to me and said that, oh, actually my husband passed away. So actually now only me and my husband's parents, three of them. So you know, she wanted to do it so much, and she really want to get it done because it's very, it is lingering in her mind, like, you know, this has not been solved yet. So you know, I don't have the peace. I want to get everything solved and such, and get the money and settle the debts and whatnot. But the parents-in-law didn't agree to let her be the administrator. So there's a lot of disagreements in between, like, okay, I don't agree on this, then how about the money after, you know, you obtain the distribution order, like I'm like, the parents-in-law were afraid that she will misuse the money, or she will get a portion of that money for her own benefit. So but my client, she just wanted to get things done. So there's a lot of, like, you know, unnecessary conflicts and also disagreements in between. That's why the case prolonged, and until just last week, I just filed the application for the LA. So it's already 1 year and 2 months. So that's why if you don't have a will, it will cause a lot of disagreements between the family members, and also some, I mean, this is the reality lah. When somebody's around, they trust you. They think that, okay, you are my son's wife, so I trust you. So once, you know, my immediate family, my son or my daughter has passed away, so I don't trust you so much anymore. I mean, this is very real lah. I mean, it is a very sad truth, but this happens to most of the people who has, you know, who has children, or you know, who has whoever who passed away. So the relationship will turn sour just automatically lah, without any reasons, because you know, my son or my daughter has passed away. So naturally you become like my rival or my enemy. So anything regard to in relation to money, they will feel very sensitive. They'll be like, oh, what if, like, you know, stuff like that happens and such. Okay, so that's a very, I mean, this is a very good case study, because many of them, they don't know. They think like, okay, no will, then do LA lah. Same process ma. But then it's not that easy. It's not that easy. There'll be a lot of, like, in between, you know, a caveat from the bank, and also usually the biggest headache is between family members, because if you cannot come to an agreement, things cannot run. Things will be stuck there for, you know, for 1 or 2 years, 3 years. Even for LA application itself, right, it will take 6 months or even up to 1 year to get the grant to distribute. But then if you add on to all these side conflicts between your family members, it will add on, it will prolong the application time even longer. So why not just write a simple will, or you just draw up a proper will, so to avoid all these conflicts between your family members. Okay. So the next one is to make gifts and donation according to your wishes. Okay, so actually will is very interesting, because you can just write anything you want, or how, like, which organization you want to make a donation, or you want to give your special collection to your maybe your friend and your close friend or your family members or your relative as well. So it's very interesting because this is the only instrument other than trust, of course, that you can do this kind of arrangement. So if without all this, right, it will follow the Distribution Act, which we will go through later. So everything will follow that act. You know, your assets will be distributed according to the act. So later I will show you the list of people who will get your assets if you don't have a will. Okay, it's a bit scary because yeah, later you will see. Okay, so we will go through this first. We will finish these slides off. The last one is reduce family conflicts. Okay, so like the case study I gave just now. So once you have written a will, nobody can actually, you know, challenge like, hey, actually this is not fair. Like, you know, actually I should get more. Actually, you know, I've done so much in this person's life, then why am I entitled so little? Okay, so actually it will save you know, the family from all these conflicts, because this is the disease wishes and will. So we cannot, like, you know, there's no way we can really challenge it unless the will has not fulfilled the requirements, the law requirement, okay, that we will go through later. Okay, so far this is 6 main points why should we write a will. Okay, so a will, there will be we call it clauses, means paragraph lah, basically. There's mandatory clauses, means these clauses must be in the will. Okay, there's also optional clauses. Later I will go to that. So we will go into these mandatory clauses first to let you guys understand that what actually should be contained in the will. So there's two categories. One is the mandatory one that you must include in your will, and the other is optional. Okay, so the first one is opening clause. This is the clause which states that, okay, I, Nicolau, IC number, address, has written this will on this date. Okay, this opening clause. And also next, revocation clause. This clause is to cancel and also revoke the previous wills that you have done. Like, let's say maybe 3 years ago you have written a will, or you know, many wills you have done it before. So this latest will, we write this clause to revoke all the other previous wills, so that the other wills has no effect anymore, and this is the latest will. Okay, so everything will follow the latest date, the latest will. Okay, the next one is appointment of executors. This also must be included in your will. This is mandatory because you have to appoint somebody to be your executor to execute the estate. And also for trustee, you know, executors and trustee, they come hand in hand lah. So usually, you know, if you don't have you know, specific arrangement for trust, so usually we will just put the executor and the trustee the same person lah, unless you have like a special arrangement, like you want to appoint a corporate trustee to administer your trust assets. So that will be a different case. Okay, so the next one is how you want to distribute your asset. This is very clear. So without this, actually can also like somebody, but we believe that everybody has assets, you know, regardless of maybe just a little, like a cash, or you know, maybe the cash in your Milo tin and stuff like that under your bed. So at least we have something to give away, or something, you know, meaningful to us, like our collection, or you know, things which has passed down from our maybe our ancestor, our great grandparents, or grandparents, who, you know, is very valuable and also meaningful to us. So I believe everybody has something to will out. Okay, so this asset distribution clause is very important as well. It will determine like how you want to distribute your assets to whom and such. Okay, so the last one, which is very important also, it is the residuary clause. Okay, why is this residuary clause so important? Because actually this clause, it will cover the future assets. the future and also the unnamed assets in your will. Because usually people will name every assets, like, okay, this property holding held by which the grant title number, and also the address and such, and bank account, which bank, RHB Bank, Hong Leong Bank, and they will list it out. So maybe after 3 years or after 5 years, they have acquired more properties. So if you don't update your will, actually all these unnamed assets or future assets, they are still being covered under this residuary clause. Okay, so that's why this residuary clause is very important, because it covers the future assets and unnamed assets in your will. Okay, but we really suggest and also recommend you to rewrite your will and also update those, when you have assets and also properties added into your life, like you buy more properties, or you selling off or disposing of is not a very big a very crucial thing yet. If you have included into your will and you sell it off, it doesn't matter. It doesn't concern, if you don't have at the moment of your death, so it doesn't concern the property anymore. So it will just, those still under your name, that will follow your will. So what about the unnamed and the future assets? They will follow this residuary clause. So from what I mentioned just now, if you just by relying on this residuary clause to include all your future and unnamed assets, actually it's also very unclear, because how should your family members know, like, what future property has my father bought or mother bought after she wrote this will? Maybe she has bought 5 more properties, or she has bought something else which we don't know. So actually it's advisable to rewrite your will and also to include those you have bought recently, so that it serves as a directory to your family members, so that actually they know, oh, actually this is the latest one, so everything is included in this will anymore. So they don't have to guess, like, oh, actually don't know still, they still bought any more properties after this or not. So they might be thinking, oh, actually I still need to go and ask the bank, did my parents open, like, did my father open any more accounts and such like that. So we want to avoid, because actually the reason we want to encourage the public to write a will is because we want to save the hassles for the family members. So if you want to do it, then we do it well. We save 100% of the hassles, not only 50%. And if the 50% chincai lah, after that is their matter already. I have left, then they go and settle themselves. So I feel like it's more proper, if you want to leave love to your family, so we do it wholeheartedly. We update once we have bought any more properties. So this will also lessen the headache of the executor and also beneficiaries. Once like stuff like that pops up, right, they will have to run here and there, like banks or land office, and search for the properties under whether this disease has bought it or stuff like that. It's very headache lah. So okay, you want to save it, save all these hassles. Okay, so the next one is optional clauses. Just now I mentioned that that slide is for mandatory clauses, which those clauses have to be in your will. So this is optional. The first one is appointment of guardians. This is for those who has minor children, still minor children. So you have to appoint a guardian to take care of them. Okay. The next is in special instructions. So this might be, some people, they want to give special instruction to their family members or executors, to do what specifically, like, special instruction I have, like safety box in which bank and stuff like that, the password is what, blah blah blah. So you can include this special instruction in your will as well. And also lastly, the next one is testamentary trust. This is a form of trust as well. It is written in the will, which we do not recommend, because why we want to start up a trust is because we want to expedite the process. Will, you have to go through probate, but then if trust, you don't have to go through probate. You just it will start having effect after the person has passed away. So if you set up this trust in your will, it has to go through probate as well. So it actually defeats the purpose lah. So we will recommend you to set up a private trust or you know, insurance trust and such. This we will have our Dato Lee to share with us this afternoon. So stay tuned. So the last one is the terms of endearment. Okay, last words now we call it. So actually you can include like your last words. Some of the people, they are not very good in saying face to face, like appreciation words and such not. So you can write it in the will. Okay, we have some ideas from our participants. Can we like make a video and stuff like that? So it's like more, you know, more feel lah, which we also encourage, because by reading words, it's just words. So we can do it in a very creative way. You can take a video and, you know, you can place the link in your will, and also like password and stuff like that. Maybe your YouTube link, which is private, so only your family members can see. So from there, you know, they can access into your video. You know, like when you see this video, I'm not around really, so you can, like, you know, you can say some of the things you wanted to say when you're alive, but you don't have the courage to do it. So it's very up to, you know, it's very fun lah. But you can include a lot of things in your will. Okay, so I have question here. What is the definition of minor children? So okay, okay. So later we will go into that. That's 18 and 21. So a lot of people are they are very confused on, like, you know, what is the age. So this we will go into that later. Okay, so where will your estate go if you don't have a will? Okay, so like we mentioned just now, if you don't have a will, your estate will be distributed following the Distribution Act 1958. Okay, so what is the how is it supposed to be distributed? So let's go into this married individuals first. So if you are married and you has if this person has already gotten married and already passed on, so we will see whether, like, who is being left. Like, okay, maybe you pass on and you only have your spouse, only spouse is alive. So your no parents, no issue. Issue here means children, and also, you know, future descendants of children. So if you only leave behind your wife or your husband, so your wife or husband will be entitled to 100% of your estate. Okay, so likewise to the two scenario, which when you only leave your children behind, so your children will get 100%. So this will depend on how many children you have lah. If you have 5 children or you have 6 children, so it will be equally distributed to them. Okay, so the last one is the when you have parents only, no spouse or no children, so your parents will get 100% of the estate. Okay, so it's very clear when you are married and you leave behind only spouse or only children or only parents. Okay, so okay, for this scenario will be having two categories of family members around. The first one is spouse and parents. If your spouse and parents still around and you have no children, your spouse will get half, your parents will get half. Okay, so parents half means if both parents still alive, then both of them will share the half lah, 50-50. Okay, so if you leave your spouse and children and no parents, the spouse will get 1/3 and the children will get 2/3. Okay, same goes to only leaving behind parents and children and no spouse. Your parents will get 1/3 and your children will get 2/3. So actually we can see that, you know, The difference here is that children will usually get a larger portion of the estate or the money. I think we can understand from this is because, you know, children, they are still young, they need more money to sustain their life, and also, you know, they have education, they have like more expenses to you know, to spend on. So we can see that, always remember that if you have children, or if the clients have children, the client's children will get more portion. Okay, so the last scenario is when all the parties are around. Okay, like parents, spouse, or children. So the distribution will be one quarter will be to the parents, one quarter will be to the spouse, and the leftover, which is the half, will be distributed equally to the children. Okay, so next we will go to unmarried individuals. Just now we mentioned that mentioned on the married individuals. Now we will go to the unmarried one. So section 6(1)(1) and J of Distribution Act stated that if an unmarried person dies without a will and has no children or parents, means, okay, no parents, no children, and no spouse, nothing. Okay, so unmarried here, the definition of unmarried is single or widowed or divorced. Okay, so these three categories of persons, they are considered unmarried individuals. So the first question they will ask is, do you have any brothers and or sister, brothers or sister? So, you know, if you have not written a will, they will first ask, do you have brothers and sisters? If you don't have, then they will ask you, do you have your grandparents? Okay, if there are no grandparents, then they will ask you, do you have any uncles or aunties? So you can see that, you know, it's getting further and further away. Okay, so the next question is, do you have any great grandparents? If not, then do you have any great uncles or great aunties? If no, everything goes to the government. So you can see that, you know, actually, if you don't just draw up a simple will, and let's say, you know, who knows that we will, you know, if touch wood we get divorced, or stuff like that. So end up single or whatnot. So this will be the situation. So actually, it's very scary, because if you ask me, right, I really don't want my assets, or, you know, my hard-earned money to go to these people who I don't know. Because if this goes to them and they are, you know, if they attain the money and they just pass away like that, then it will become their estate and their beneficiaries will get the money. So it's like giving free money away to people you don't really know and not really close to. So it's not very wise lah. So let's just really think about it. And also, you know, like, if we don't do this right, these people whom we, not that, you know, not that we are not kind enough to, you know, just give the money to them, but then you think and you imagine these are all your hard-earned money, and of course you want to give it to people who are, you know, who are dear to you and who took care of you, who raised you up and such. So I think it is more wise, and it is wiser to do a proper planning to give your money and your assets to the people who are close to you. Okay, so okay, this situation just now I mentioned, just want to let you guys know that actually marriage revokes a will, but divorce does not. Means that if you are married, if you are single and if you have written a will when you are single, then maybe after 2 years you got married. So actually that marriage will revoke the will you have done when you are single 2 years ago. So that will actually has no effect anymore, because you are already married, so you have a new life. But note that divorce does not. Means let's say today you are married, then maybe after 10 years you divorce. You get divorced. So actually, when you are married and you wrote a will, and when you are divorced, the will is still valid. So actually it's very dangerous lah, because once you are divorced, actually you cut ties with maybe your ex-husband or ex-wife, or maybe you know, the children. I don't know, maybe you know, you don't care about your children anymore. So people will tend to, you know, change the list of beneficiaries. So to me, I suggest that maybe either marriage or divorce, both situations, or you have like newborn babies, and you know, more family members are being included. So it's very logic lah. It's very logical to write a new will, because you have more, you know, different individuals that will be in your life after, you know, something happened like marriage or divorce. So it is better for you to rewrite a will. Okay, so we will go into the formalities next. Maybe we want to get a break. Okay, we have a short break, 10 minutes, and we come back around 11:20. Is it okay? 11:20, we will start on the formalities of will. Okay, see you guys later.
Yes, no? Can I? So if you guys are ready for the next session, you can write in the chat box, say yes. Okay. Okay.
Excellent.
So, okay, I see a few yeses. Okay, is everyone ready? Okay, all right. I'll pass the mic back to Nicole.
Okay. Hi, welcome back. So we will continue our next session. Okay. So next we will go into the formalities of a will. Like what are the requirements we should take note in writing a will. Okay. So it is very clear that you have to be of a certain age to write a will, because you have to have some decision making ability. So hence why the law requires the testator. The testator means the person who will be drawing up the will. Okay, let's say I want to write a will. I'm the testator. So the testator has to be 18 years and above. This is required by Section 4 of the Wills Act. Okay, so means 18 years and above. Second, sound mind. Oh. Hello. All right, sorry. So second, you have to be sound mind. Means you have to be clear of like what you are doing, like what basically what you are doing. You must be aware, and also you know that this is what you want to do. Like I want to draw up a will, and today I'm signing this. You know, you have to be that sound mind. This is required by Section 3 of the Wills Act, and also thirdly, actually will can be written in any language, Mandarin, BM, or you know, maybe any foreign language like Cantonese and such. But then the thing is, because at the end when you apply for probate in High Court, the documents have to be in English. So actually we recommend that, you know, the will to be drafted in English. When the testator they don't really understand English, and we can do a translation, like we can translate the meaning of the will to them. Like we can say that, okay, actually you are writing this, and this means, this clause means this in Chinese or in EM or in, you know, other languages. So we have to explain to them and make sure that they are aware and they know what are the clauses, what the clauses are talking about. Okay, so because we if we don't do this, next time, let's say if they don't understand, or you know, their beneficiaries come and challenge and say that, hey, actually my father, he don't know
English also, he only speak Mandarin. How come he get to, he signed this? Must be, anyone who wants the benefit, who did this lah. So actually we will have a clause which state that the testator has already been explained in the language known to him, and he already understand what this will is all about. Okay, so actually we recommend, we really recommend to be written in English, because we don't have to, spend time to do translation from Chinese to English, from BM to English and such. Okay, so because by doing translation, we will also have a charges there. So we don't recommend to do it in other language. Just that you just let us know how you want to distribute in like Mandarin, or you just talk to us. Like if those people who are not very fluent in English, they can just tell us in Mandarin or BM, then we can just drop it out in English for them. Okay, so the next one, number 4, this is very important. During the signing, the testator have to be present together with 2 witnesses at the same time. This is required by Section 5(2) of Wills Act. Means that today, if I write a will, I must have 2 persons to be witness. Okay, to witness the signing of the will. Means when I sign, they have to witness the signing. And these 2 persons, later I will go into details. This person, we have requirements for these 2 persons as well. Okay, so this is just a general idea that this is one of the formalities of writing up a will. So when you are writing up a will and when you are required to sign it, there must be 2 witnesses. Okay, so number 5, it must be in writing. This is required by Section 5 of Wills Act. Okay, so it cannot be done in audio or video or any form. It must be in black and white in writing. Okay, so number 6, signed by the testator or any other person in testator's presence or by his direction. This is written in Section 5(2) of Wills Act. Okay, what does this mean? So some of the testator, right, actually they are sound mind, but they are restricted by some of the maybe their hands, they are not active anymore, maybe they cannot sign it. So actually he can sign it by himself, like maybe a thumbprint, or any other person can sign on his behalf, but the requirement is that the testator must be present, and he must direct that person in front of in front of the witness lah. So let's say I cannot sign it, so I ask him or I ask Jen to sign it on my behalf, but I must be present. I must be I must witness it as well, and she must do it according to my direction. Okay, so actually those who are still sound mind, and just that their body has limitation, they still can draw a will, just that they this has to be followed lah. Okay, so basically this is the 6 requirements, the formalities to write up a will. Okay, so now we will go in depth, like what's the duty of executor, what's the requirement, and also for guardians, and also what are the requirements to be a witness, and also who are minor children. Okay, so let's very quickly go into it. The first one is the requirements of an executor or trustee. This is for individual trustee or executor. Means you appoint a person to do the job. So this person who are appointed by you must be also 18 years and above, sound mind, and not a bankrupt. Okay, so 18 years old is very clear. He must be of like some age requirement, and also sound mind is also very important, because if he's not sound, or he is not he's not normal, then maybe he's not fit. He's not a fit and a proper person to become an executor. So thirdly, not a bankrupt. Okay, this has to be taken into account as well, because if he's a bankrupt, he cannot be an executor. Okay, because to logically, because when he gets the money, we don't know what he will do. Maybe he will spend it to clear his debt, or things like that. So must be very careful in appointing your executor to make sure that this person, there's no way, or there's no possibility he will be a bankrupt. Okay, so additional information, this executor can also be one of the beneficiaries. Okay, so meaning beneficiaries can also be executor. And also this is very this makes sense because in order to make the executor work, you have to give him or her something in return. So he will also, the person will also work willingly lah, like okay, at least I will get something in the end. So it will smoothen the whole process, and it also will at least he gets something, so he will push himself to work. Okay, so next, if the beneficiaries is minor, there must be a minimum of 2 executors. Okay, so if you have minor children, there must be 2 executors to jointly administer your estate. So let's say, okay, minor, okay, I will just mention first. Minor children here means 21 years old. Actually 21 years old means if you have 21 years old of children, 21 years and below, so you have to appoint 2 executors jointly. Means they will work together to administer your estate. Okay, so this is because we have to have this check and balance, because we have minor children as beneficiaries. They wouldn't know, like how things are going to work. So if you have 2 to work and also to distribute, and throughout the process there will be like of course you have to appoint someone you trust lah. So if 2 persons in the end they pakat and they do something else, so it's not very good and also not very morally right lah. So of course we as testator, we have to make sure that okay, this person is really trustworthy. I really trust this person to administer my estate, to take care of my children and such. Okay, so for this kind of case, when you have like minor children, you have to have minimum 2. Okay, so remember, if you have clients, your clients, of course you will interview them before you write a will. So if you know that they have 21 years old below of minor children, then you have to let them know, okay, minimum is 2 executor joint. Okay, because this is required by the law, not by us. Section 4.2 of Probate and Administration Act stated that if you have minor children, 2 minimum executors are to be appointed. Okay, so actually section 4.1 of the Probate and Administration Act mentioned that you can actually appoint up to 4 executors, but we usually do not suggest or recommend to appoint too many, because there will be more people, more conflict. So let's just follow the law. If you have minor children, minimum 2, and also if you don't have minor children, and without any children, you just appoint 1 will do. So we usually will recommend and suggest, if you have 2 joint executor, it is advisable to appoint 2 more to be the substitute executor, just in case, like if any of them, let's say I appoint A and B first, but let's say A and B could not act, or either one could not act, so we have 2 names to be on hold, like to stand by. So anything happens to them or they are not willing to act, so we have 2 more names to replace them. If you just appoint 2, let's say one of them, they are not willing, and also, or maybe they have passed away, so only left 1. So you have to trouble yourself to appoint another through the court, and have to make an application as well. So it's better to name the main executors and also the substitute executors in your will. Okay, just so to save any hassles in the future. Let's say if anything happens to the main executors, we have the substitute to stand by. Okay, so for the situation C, can appoint up to 4 executors. Just now I mentioned that we don't recommend, because if too many people are to be appointed as executors, I'm sure there's like ways, every individual, they want to, there's different ways they want to work things out. Maybe this, they prefer this kind of method, and this, they prefer that. So it will it will also turns up like, there's a lot of conflict and also disagreements. So this might also prolong the application of the probate. So actually, we don't recommend. If you have no minor children, just one will do. One main and one substitute executor, or maybe two substitute. Okay. So this is the requirement for executor. So actually, what is the duty of an executor or administrator? Okay, executor here means if you have a will and you appoint an executor to execute your estate. So if you don't have this will, this person will be called administrator. Okay, so actually their jobs is the same. It's just that they have different names or terms. Okay, so firstly, their duty is to first settle the funeral expenses, and second, to pay debts or any tax owed by the deceased to the tax pay tax, and also lastly, only they can distribute balance of the assets to the beneficiary. Means once the executor got the money, and the first thing he or she should settle the funeral expenses first. Maybe whoever who fork out the money to pay for the funeral expenses, so you have to pay back to them, unless it is on their own willingness or wishes that it's okay, I want to pay, I want to contribute something to this disease, or he's my father, he's my close relative, so it's okay, I don't want. So actually it's up to them So but this is the requirement of the executor, what he or she should do after obtaining the money. Okay, so after that is to pay whatever debts, because actually if executor does not execute well, means like he did not settle the funeral expenses, he did not pay any debts. After that, if after that you haven't make sure everything has been cleared, only you distribute, right? After that, maybe you have all these people who say, hey, actually this owe me money. So like, if I'm the executor, I didn't make sure that who are those creditors. So I already distributed out already. So like, what am I going to do? So actually, the executor bears a responsibility. He has the responsibility to pay the debts first. If not, then he will be personally liable. He has to take up all the responsibility. Then he has to maybe take out from his pocket and stuff like that to pay, because he was ensured, he was being appointed as an executor to administer the estate. So he has to fulfill all the duties first before he can distribute the balance of the assets to the beneficiaries. So you must let this client know that this executor is a very important person. It's not like you just appoint, then after that, okay, just distribute my asset. He has to go through the process of settling funeral expenses, paying all the debts. Okay, paying all the debts, just to protect he himself, that if any creditors come, you at least you have settled everything, so they won't personally go after you, or else the executor will be personally liable. Okay, so next, okay, just now I mentioned that beneficiaries can also be executor. So because a lot of people ask us, then who shall be the executor? Like, who do you suggest? So actually, we suggest that the beneficiary who will inherit the largest percentage of the estate shall be appointed as the executor. Because very logic because you appoint, if let's say I'm the beneficiary who get the largest percentage, of course I will feel that, hey, actually I should do it well, and I should carry out this duty in a efficient manner, and also do it fast, because I have something behind. I can get I have money, or maybe properties and stuff like that. So I mean, to we as a testator and people who want to do this planning well, we should take into consideration, like, okay, this is a more logical way. If I appoint this beneficiary, he will work, he will do things better, because he will inherit the largest percentage of the estate. So there won't be like, 75% to A, then you appoint B who will get 25% to do that, to administer your estate. Of course, the person will feel that, hey, I only get 25%, and why I was so hard. I have to go to find a lawyer, have to go to court. After that, after obtaining the grant, I have to go to bank. I have to settle the debt. I have to do this, do that. So usually people will feel very mafana, like you so much hassles. Then 25% only, so no need lah. So I just leave it there lor. So then it will cause conflict again. The 75% of the the beneficiary who will get the 75%, he will maybe uh you know disagree and this and that, then it will prolong the thing again. Also, actually, if you have a will in this situation, it amounts to no will, because in the end, nothing goes on, nothing has proceeded. So we have to be very wise in planning our estate, no? Okay. So you can see from this reported news, sorry, it's in Chinese, it's in Mandarin. It says that the deceased who owe the tax and also any debt, they still have to pay, even if they have passed away. So the responsibilities uh, falls on the executor or the beneficiaries. So actually, the beneficiaries or the executors still need to pay the debts first before distributing the assets to their family members. Okay, so this is not only we making up stories and just to scare you. This is actually reported in the news. So I mean, as you can see, this is a real life situation lah, not you just simply say you all just want to get more people the right will to make money, because actually we have seen a lot of cases which clients, they don't have will, so they will meet a lot of problems. That's why, like me, right, whenever I meet all these clients, because it's very emotional, it involves like a lot of estate, money, and relationships and stuff like that. So it's very heartbreaking. Like you see like those father and mother so old already, they still come here and say, oh, actually, I just want to get things done. I don't want to fight. I also don't want their estate and stuff like that. So it's very emotional. Every time I meet my clients, right, when they are elderly people, I will feel like a sense of like a very heavy feeling lah. Like why should they go through this even when they have reached this kind of old age? I mean, they shouldn't have, like they wouldn't need to put themselves in this situation to go through like this. One of these clients, right, he's um it's the same case I mentioned just now, the LA case. So I said that this client, her husband passed on, so left her and also the parents-in-law as beneficiaries. So at first, right, this my client, she wants to apply for LA. So in the end, both of them actually they disagree. They say that, oh, later you misuse the money, you mismanage lah, you take it and you use it for your own benefit. But then this case was running, on and off it. Then this client even want to have like an agreement with the parents-in-law, like after LA is granted, after distribution order is granted, I want to, I want this, I want that. They have terms like that. So recently, just now I mentioned the client just came and signed recently, and I filed last week. So he brought his father-in-law together. So actually, in the end, actually there are three separate individuals. These parents-in-law, they are not together anymore. So actually, this father-in-law, he thinks that his wife is being very bossy, being very mafan and being very lebih lah. Like you do have to do all this. Actually, what our daughter-in-law wants is just to clear the debts and to just get everything done lah, properly managed. So actually, in the end, the father-in-law actually also being convinced by the daughter-in-law to get things, to expedite the process. So actually, the uncle came lah. This father-in-law came with my client. So throughout, I also feel that he was being very disturbed, also being very annoyed by things like that lah. Like, why cannot proceed? I just want to, just want to get the money. Actually, he don't want the money. He said that I have my own life. I have a property to stay and stuff like that. I don't want to be involved in this. He said I'm already very old and stuff like that. So you get very emotional lah. Like, you also old already. You still need to go through this and stuff like that. We feel very, I really sympathize them lah. I feel actually they don't have to go through this. That's why on the spot I told this uncle, I say, uncle, you have to write a will. I said you have to write your own will to prevent, things like that happen lah. You see your own son, his son pass away without leaving a will. So that's why, between all this, right, there's disagreement, there's breakdown of relationship, and also you see the estate is being frozen and stuff like that. So let's say if this client of mine, she has minor children and they depend on the husband solely. So, when should they get the money? If, like, they cannot agree to proceed with the LA application. So forever, like now, this situation is 1 year and 2 months. So can your beneficiary last without your estate for 1 year and 2 months? So this is the question you have to think. Like, okay, if I'm not around, immediately will they have money? So if they have money, then it's okay lah. But then it's not wise lah. It's not advisable. So it's just by writing a very simple and proper, will, then that's it. Okay. So yeah. So okay, let's move on to the requirements of guardians. Okay. So who should be a guardian? Similar to executor, first is above 18 years old. Second is a sound mind. Third is this guardian is capable in providing basic financial support to the minor children. Means, he or she must be financially stable, like they have enough money to support the minor children on their daily basis, their life, their medical, or maybe their education, okay, or their some of their tuition fees or living expenses. Okay, so number 4 is that this guardian, he or she must be capable to take care of the minor children. Means, not okay, financially support is one thing. You have to be capable to take care of them. Like, they are sick, or they need this, they need that, they have to go for tuition classes or this and that. You have to take care of their welfare. Okay, so there's one note here. Please note that the spouse will be the natural guardian. So let's say in the will, right, actually we will draft it in a way that if let's say I'm not around anymore, my spouse will be the natural guardian. This my husband will naturally be the guardian. So I will usually give ask clients to give one main guardian and one substitute guardian, same as the executor, just that the spouse will be the natural guardian first. Okay, let's say in the accident, both of us, me and my husband, pass away at the same time. So the main guardian will come in to carry out his or her duties as a guardian. Okay, or else my spouse will be the natural guardian. Okay, so here actually you can appoint joint guardian, or you want one sole guardian also okay. So it's the same. If you have one main guardian, so you will have to give one substitute guardian's name. So in any event, you have this name to replace. So if you have two joint, then you have to give two more names to be the substitute guardians lah, just in case if anything happens to the main guardian. Okay, so okay, this is the question. Just now I saw somebody ask, who are minor children? Okay, so Guardianship of Infants Act stated that infants is a person who has not attained his or her majority. So Age of Majority Act Section 2 states that the minority of all males and females shall cease and determine within Malaysia at the age of 18 years. This is actually just now Jan has already mentioned that minor minor children is 18 years and below. But but according to Guardianship of Infants Act, it's a bit different lah. Section 2(a)(1) state that every person professing the religion of Islam shall be deemed to have attained his majority when he's completed of his age of 18 and not before. Means in Islam, 18 years and below, they are called minor children. 18 years and above, they are called adults. Okay, so but then looking at our context, we are not professing the religion of Islam. So we are all categorized as the one below. Section 2(a)(2). Every other person other than the religion professing the religion of Islam shall be deemed to have attained his majority when he shall have completed his age of 21 years and not before. So the conclusion is, for Muslims, minor children are 18 years and below. So for non-Muslim like us, Chinese, Indians, or even other races other than Muslims, our age of our minor children are considered 21 years and below. So just remember, if 21 years and below, they are called minor children. So if your clients have 21 years old and below children, so they have to appoint this guardian to take care of their children. Okay, clear? Right. So actually it's a bit funny lah, because every time you will mention that, I thought, guardian, you can appoint somebody who is 18 and above, but you have to take care of somebody who is 21 years and below. So actually we don't know how the law works and what's the logic behind it, but this is this is the law lah for minor children. Okay, so actually have to take note on this. A guardian of a minor children automatically ceases his or her duties and obligation when the child attains 21 years of age. Means after 21 years old, actually this guardian wouldn't have to play the role as a guardian anymore, because the child has already attained 21 years of age. So he can, he has his freedom to decide and also to live his life. But a child can inherit the properties when they attain 18 years of age. Means to inherit the property, once they reach 18 years old, they can inherit the property already. But only until 21 years of age, only they have the freedom, from being taken care by the guardian or being controlled by the guardian, and so on. Okay, so take note of this. So okay, requirements of two witnesses. Just now we mentioned that there are a few things we have to take note. Okay, first we go through first. To be witness, you have to be also 18 years and above. You have to be sound mind, means you have to be capable in your mental health, and also thirdly, not beneficiaries mentioned in the will. Okay, this is very, very, very important. Have to take note. The witnesses who witness the testator who signing the will, right, cannot be the beneficiaries mentioned in the will. The logic is very simple. You cannot witness somebody to give you the assets or the properties. Okay, so bear in mind that if your clients, after we have done the will for you, after printing out, you go and see your clients for signing. So you have to make sure that, okay, maybe clients say, because we can be the witness for the will, but then some of the clients, they are more, particular. They want to find their own witness. Okay, this is fine, but then you have to inform them that, you want to find your own witness is fine, but you cannot find those you have named in the will as beneficiaries. Let's say, let's say maybe he say, hey, I only give this beneficiary a very small part only, maybe like just a small amount of money. But the truth is, you cannot name the person. You cannot ask the person to be the witness. If he or she be the witness, that particular clause will not be having any effect. Means he won't get the money, because it's in contrast with the law. Okay, because the law requires that the witness cannot be the beneficiaries. So once you find someone who is the beneficiary to be a witness, so automatically he cannot inherit the properties in your will. So have to be careful. Not everybody can be the witness. Okay, I mean everybody can be the witness except for the beneficiaries. Okay, so actually we will recommend and we will suggest and advise you to tell your clients to have an independent third party to be the um, witness of the will. Okay, so actually many of the participants, right, they will ask, if I find someone who I don't know, whom I don't know, so when I pass away, right, so where to find the witness, like how to locate them and stuff like that. So actually don't have to worry, because actually if the witnesses cannot be found, we can just write in the affidavit that we have tried our best to locate the sorry to locate the witnesses. So the court actually is very lenient on this. They will not trouble you lah. They won't be like, okay, cannot, you have to find the witness, you have to get their signature and stuff like that. So actually it doesn't matter. So you don't have to worry if you cannot find any witnesses. If your clients, they don't have anyone to be their witnesses, you can actually ask them to come to our office. Our lawyers, we lawyers, we can be the witness. Okay, or else, actually, when you bring the will to them, you can bring along another friend, or to be the witness for the person's, for your client's will. Okay, so need to remember that have to make sure that the witness, the witnesses, right, is not the beneficiary mentioned in the will. Okay, it's very important. Okay, so after sharing about the requirements and also the formalities and also some reported cases on the sharing on the will part. So I just want to make a very quick conclusion on the difference of having a will and without a will. Okay, so with will, right? Okay, let's see governing law. So if with will, it will be governed under Wills Act 1959. If without will, the distribution will follow the Distribution Act 1997. Okay, so if client asks, then you can very professionally tell them that, okay, if you don't have a will, then you follow Distribution Act. So you just name it, like just now how I told you guys, like your brother and sister, your grandparents and stuff like that, until in the end it will go to the government. So it's a very good way to educate them, because actually a lot of people, they don't know about this. They think that it's very it will 搞定 for me one lah, government will do it for me and stuff like that, or my family members will do it for me. The truth is, it's not. You have to go through a lot of process to obtain the grant and such. Only you can proceed to distribute the assets. Okay, so have to educate your friends, your family members, most importantly, so to save them from all these hassles. Okay, so the application which need to be made if you have a will is called grant of probate. This is only one process. So if you don't have a will, you have to go through like two process, which is the letter of administration and also the distribution order. So it will prolong the application time lah, because one application maybe it takes around 3 months or 3 to 6 months. So maybe two, it will go up to 1 year, because actually we cannot predict how long it will take for the court the court officers to process the paperwork and stuff like that, and we cannot push them. We cannot demand them, hey, I want it to be fast and stuff like that. We have to follow the date set by the date, the hearing date and the other date set by them. Okay, so just now I also mentioned the person to be appointed to administer the deceased estate. If there's will, it will be the executor. If without will, it will be the administrator. Okay, so the period to obtain the grant of probate and LA for will is 2 to 3 months, and also without will is 4 to 6 months. So this is just a rough figure, a rough estimation. It can go up to maybe with will nowadays, because after MCO, right, a lot of government departments, they tend to slow down because they have to, spread out the time and also diversify their cases because of the SOP. So, they will tend to prolong the period for even longer. So maybe, for grant of probate now, it can go up to maybe 6 months or three to 6 months, or without will, 4 to 6 months or even 1 year, it's up to them. We can only do our best to try our best to expedite the case, but then it's still up to the court officers to decide. Okay. And also, very logic, if you have one process, it's only 5,000. This is the market price for the application of grant of probate and also LA and DO. So if letters and administration and DO, it will cost 8,000 for these two process. So why not you make a will now? Maybe it just costs you 1,000 ringgit. Maybe you can share this to your clients. So in the end, you only need 5,000 to apply for the grant of probate. So you save another 2,000 ringgit in the end. So, proper planning now, maybe, you'll be very, taking a lot of time, or you have to, spend a lot of effort to do searching and stuff like that to plan properly. But then in the end, it saves you a lot of time and also hassles and also money. Okay, so all this, right, actually have to be paid by your family members, have to be paid by your executor, your family members in order for them to obtain the grant of probate or the LA or DO, because you're already not around. So, like if you ask me to imagine, when I'm not around, I have to ask my family members to pay 8,000 just to get the LA or DO. I will feel, of course, like, I'm not around already. I cause so much trouble. Then, in the end, I have to, even when I die, I also have to ask my family members to pay for this. Like other than funeral expenses, maybe they already fork out some money to pay for that. So for this, what I can do now is to plan properly to save. Maybe we can allocate some money for them. Okay, this 5,000 is for you to keep now. Then maybe if anything happens, you can use this money to apply for grant of probate. Anything which requires all this, right? Actually, you can do it now. You can prepare in advance. You don't have to wait for, I wait for 60 years old to come, then only I plan lah. I mean, we cannot predict what will happen tomorrow lah. So, I mean, if we are aware of it now, we can just make a simple will first. If we don't want to be, don't want so many headaches and stuff like that, just write a simple will stating, okay, what I have. Most importantly is your properties and your land, because all this, it will cause a lot of disagreements between the beneficiaries because the value is big now. Okay, so actually it is advisable to just drop a will. So I will go to the questions after that. I will finish off this list of services and charges first. Okay, for Lee and Partners, we have a few services. The first one is will writing services. So for the first 20 clause, our charges is 1,000 ringgit. Okay, 1,000 ringgit. So anything below 20 clauses, we will still charge 1,000 because this is our basic fee for our will. So for every additional clauses, we will charge 50 ringgit per clause. So let's say your client, in the end, the will has 30 clauses, 30. So it will be 1,500. So this is the total cost of your client's will. So if based on this 1,500, so your commission is 40%. Okay, 40%. So for this, after attending today's program, right, we will be giving out a free will to you. So you can use this will to, you can plan for yourself. Maybe if you have already written, maybe you can give it to your family members or your friends who need it, or maybe your parents, your grandparents, or your people who need it who cannot afford to pay lah. Maybe you can do a kind act of a kind act to give out this will if you have written. If you have not written, this is a very good opportunity and also a very good timing to write your own will to protect your own asset. Okay, so we will be giving out a free will worth 1,000 ringgit. So whatever additional, then you just top up the balance. Okay, so the next slide will be will rewriting. Means today if you write a will with us, your clients write a will with us, maybe cost 1,500. So when the clients maybe want to update it after 3 years, so we will give a 50% off on the new will. Means let's say if the clients write the piece of the will is 2,000 after 3 years. So the client will only need to pay 1,000 because we have 50% off on the new will for clients who write the first will with us. So for your commission, we also allocate a 40% commission to you. Okay, so after that, when they rewrite, actually you also have something to you also have something to get. I mean, you can get something out of it, then you can earn some money also. So you have to remind your clients, or you have to ask them like from time to time, maybe after 2 years, 3 years, hey, have you added any assets or properties? Have you bought any new assets? Or if you know when he wrote the will, right, maybe he's not married yet, then he's married already. So you can educate or remind them, actually, if you have like major changes in your life, right, maybe it's time for you to update your will. Okay, so actually for the third services, the third service is the will custody. Actually, we also have our own will custody service here at DM Partners. We have our own safe. So if your clients are interested to deposit their will here in our safe, so they will just pay 500 ringgit. This is a lifetime service. So regardless how many times you want to take out your will or you deposit a new will, you won't charge the additional anymore. Okay, so it's only 500 ringgit. And if your clients they are interested to get this service from us, tomorrow we will show you in the system how we are going to how you can easily just tick the box and you can proceed to make the payment. Okay, so we will have a record, and we will keep your wills in our safe. Okay, so the next slide is when there's a will, there's a way. Okay, so when you have will properly done, actually it saves you from a lot of unnecessary headache. I mean, not you your family members, because you're not around anymore. So actually those clients who come to us to apply for LADO, they are all suffering from things they are actually they didn't expect to happen. Maybe maybe they thought like, one my parents passed off, and I will get maybe some money, some property, but they don't know they actually have to go through this process first before they can get the estate, the parents' estate. So in order to prevent all these hassles and to have a smooth sailing process, a will is the basic instrument that everybody must have. Okay, it's just a matter of time because to be frank, everybody will die, but then you don't know when is your time. Maybe God calls you like tomorrow, or 3 years after. We wouldn't know. I myself, I also don't know. So I mean, at this age, maybe I'm still young, but there's something I can build off. Also my bank account, my EPF, maybe I have like one car under my name, and other things that are valuable to me, maybe my musical instruments and stuff like that. So actually there's a lot of things that you can build out. Like some people, they think that I no need this one, just live at home. But then some people, they think, oh, this is very precious to me, I want to give it to somebody else. Or you have any special collection and stuff like that. So yeah, it's a very good tool and also instrument to do your planning properly. Okay, so okay, I will just quickly go to the next slide. Wait, but is the will sufficient to preserve wealth for your loved one? Okay, is will really sufficient? So this one we will reserve the sharing to be done by Dato Lee in the afternoon after lunch. We'll share with you guys more on how to set up a trust and why trust is so important to people who has minor children or have like disability children or even elderly at home. Okay, so stay tuned. It's very interesting because there's a lot of ways you can do, not only using will, and also you can leverage on insurance and also other investment to set up your trust. So this is the sharing which will be done after lunch. So now we will open to the floor for any questions. So if you have any question, you can just maybe on your mic, or if you don't want, then you can just post your questions on the chat. Okay, so we will be here to answer your question. So if there's question, we will answer. Then after that, if there's no more question, we will have a break for lunch. Then we'll come back at 2 o'clock. Okay. So if you have any questions now, or you have any inquiries, you can just leave it at the chat box, or you prefer to speak it out, you can just on your mic and video, and we will answer your question. So are there any questions from the floor? Don't be shy. Don't be shy. If you have any, past experience you want to share.
Hi,
Like,
Nicole.
Hi.
Mala here. Can I ask? I have a couple of questions. Is it okay for me to ask?
Sure.
Okay. Basically, my husband passed away 10 years ago.
Okay.
And what happened was he actually took MRTA for all the properties. So before the MRTA came and all that, the LA alone took about a year to have the LA out, because there was some disputes and all that. But so that was taking a year, and I actually paid 14,000 for that LA.
Okay.
Okay, that was 10 years ago.
Yep.
So that was one. I don't know whether I paid the right amount or not, looking at what you're showing right now. Okay, the second was he had 6 properties, and the 6 properties were taken all MRTA under his name. Meaning to say, 4 properties under his name, meaning to say upon his passing, all were free from encumbrances. So that was something which I did, something where my in-laws didn't know that he actually took MRTA under his name. So everything became free, 4 properties. And 2 shop lots were under rental. I'm just sharing this probably, I mean, it's a good sharing for everyone as well. 2 properties were having tenants, and the rentals were collected by my sister-in-law. It was a joint property between my husband and my sister-in-law. Okay, so for the past 10 years, the rentals were all the while collected by her. It wasn't put into an administrator's account, although I was the administrator. And even for the LA extraction, they required 2 administrators, because my children were minor then. Only now they are above 18. So they were minor then. So, but I was actually asking to have myself as the administrator, because the interests of my kids were only me who was taking care, and not my mother-in-law. So they insisted to have my mother-in-law, which I agreed. But the entire amount of, so that was that. And so it continued until lately, whereby my brother-in-law stepped in saying, because myself and my sister-in-law, we cannot agree in terms of terms. So it was going back and forth and back and forth. But my question here is, MRTA paid all the properties, right? But still, the half share went to them. That is one. We still had, despite being paid by my late husband's MRTA, fully settling all the loans, yet the name we decided to distribute based on they take 4 properties and I took only 2 properties. And then the rental, the amount of rental was never showed to me, despite me asking why the rentals has been, only being taken by my sister-in-law. It's a co-owned property. So towards the end, they said they will just give as face value, which I actually took it because it was dragging for 10 years. So I had to admit. Okay, that is one. And there were also withdrawals done by my sister-in-law. That was after 8 days of him passing before the LA could come. Because the lawyer was writing to the banks to actually seize the account from doing any withdrawals, because my husband was also the joint account holder. But before the seize of account came, withdrawals already done. So what do we do with all that withdrawals? I know now the case is all closed, settled and everything, because at the end I decided not to pursue this further, despite me doing a lot of work as an administrator. But the amount withdrawn and everything is still, it's just like gone like that. So
Okay, thanks for your sharing, Mala. So actually you can see from real life experiences from people around us, they actually face this kind of hassles, and in the end you suffer because because of the mismanagement, and also the person didn't do any proper planning on that, so it leads to the people who are left behind, they suffer from this. So actually for your case, Mala, if you want to do it, you can claim it from yours. You can actually if your sister-in-law was fair enough, she if she was kind enough as well, she will distribute fairly to you as well. But since this case is already after so long, so the only way we can do it is to by demanding, maybe through because it's already closed ma. So one way is that you have to claim from her by maybe sending a lawyer's letter, or demand from her, or maybe it leads to some contentious matter, so you have to um sue her and stuff like that lah. So because I'm not sure if you were the one who was the administrator, right? She wasn't
yes.
named as administrator, right?
No, she wasn't the administrator.
Okay, so 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 after all those, you were the one who applied for the LA, and you went to the court to
Yeah.
manage everything, right?
The LA was applied under 2
Okay.
names, which is my mother-in-law, who is very, very old. She's during the application, she was already 78 years old. So I don't know why the court actually allowed a 78-year-old to be an administrator, when I was the one who was actually doing the entire work. For example, going to the insurance to clear all the MRTA, for the submission to all the banks. Basically, A to Z, I was doing it, Nicole. So, I really don't understand because she as a beneficiary, I was willing to give her the 1/4 because that is how the thing works. But she becoming an administrator and each time blocking what I was trying to do was dragging the entire matter.
So meaning she was also one of the administrator later on, your
No,
sister-in-law.
she was the administrator. My mother-in-law was the administrator.
Oh,
My mother-in-law and myself, two administrator, because the court said my children are minor, therefore it requires two administrator.
okay. So that time, at the point of time, you guys didn't consider your sister-in-law. And who appointed your mother-in-law? Who agree, who?
Their side, their side, my in-law side, my husband's side.
Okay. So your question now is how you could recall the withdrawals of the money from the bank. Is it?
Yeah, because upon the 8th day of his,
Mm.
I mean, after 8 days of he passing, they actually quickly withdrew all the joint accounts amount of cash.
Mm.
The cash was just drawn just like that. So I don't know whether I can recover or not now. It's already so long ago. And then the other one is basically my question is MRTA paid all the properties, right?
Mm.
Why is that not recognized that it becomes his property? Because it's due to his passing, MRTA paid. Otherwise, they would have continued servicing the loan, right?
Yes. So after the MRTA is being paid, did the name was still under your husband's name, the four properties.
My husband and my sister-in-law.
Okay, so she did the transfer of the properties to solely her name, is it?
So no, we came to a settlement agreement. Despite all this payment being made, they insisted they wanted 4 properties.
So you agreed to it.
Yeah, because it was dragging, Nicole. It was really, really dragging. And until now, how should I say? I really don't know what actually transpired between them, because to me, my husband died of cancer. He was 1 year alive. They could have told, if that belongs to them, they could have told him to write a will saying that, okay, hey, these properties belong to me, please have my name there. And not after his passing started making claims. He did not die of accident where I don't know anything, they don't know anything. They had 1 year of him still being around. You get it, Nico?
Yeah. Yep. So actually, by right, following the Distribution Act, right, she gets nothing. She gets nothing because your husband is married, and for married individuals, the person entitled to the estate is your spouse or your parents or your children. Okay, so let's say for joint properties and also for, you know, um, let's say for joint properties, actually you are entitled, and also maybe your mother-in-law, your father-in-law, they are also entitled, and also as well as your children, because you have all these 3 parties around. So actually, the persons who are supposed to inherit the half share, because you mentioned that it's joint properties with your sister-in-law, so that half share of the properties actually belongs to you, your children, and your I mean your parents-in-law. So
Yeah.
unless you come to agreement that okay, you wrote it black and white, or you are agreeable to renounce all your rights, your whatever to them. I mean, you renounce it, so you say you expressly say that, okay, I give it to my sister-in-law. So for cases like that, okay, this is an agreement. You cannot come back and forth anymore. So it's only for the bank account. One issue is that I don't know which bank was it that she withdraw all the money from, because for some of the banks, right, if you have joint tenants, joint account, some of the bank they practice joint tenancy, which okay, if this he already passed on, right, or she already passed on, the other name, the other joint account holder, she actually can withdraw the money. She actually can withdraw the money from the bank account, just that she has to distribute following the Distribution Act. Means that she has to distribute according to, you know, because this is not having any agreements between you and your sister-in-law. So the she has the duty to transfer the money that you are entitled to have it. So maybe this we can discuss further and see whether what kind of action you want to take in order to try to get back the money, to claim back the money from her. Maybe we have to
Because
have you raised this issue to her before?
yeah, through my lawyers, yes, previously, but it's just that about 2 years ago, my brother-in-law stepped in to have this,
Okay.
have it settled amicably and all that. But again, I told my brother-in-law, this is not an amicable settlement, but at the same time, I don't want to prolong this process as my children are also getting older. So I said, okay, let's go for a settlement agreement. So that's how we came to a settlement agreement on how the properties should be distributed. Although I know it's not fairly distributed, but I just had to let go for my mental peace.
Yeah. Yeah. Thanks for your great sharing, Mana. So actually we can see that if you don't, you know, you don't have a proper planning, that's why, I mean, through this kind of sharing, we can learn together and we will get to experience one another's experience lah. So you know, to place ourselves in your shoes, to think that okay, what if this happens to me one day? So am I willing to just let go, or it will trouble you from time to time? So I mean, I'm sorry to hear that, Mala. So this is one of the pain you have gone through. So for others, you know, if we have this awareness now, I think it's very wise to do our planning from today. So you know, in the future, our loved ones don't have to go through all these pain, sufferings, you know, all these disagreements and all these arguments between our own family members, which I think is very, you know, it's not worth it.
Yeah, until now, I mean, although I speak to my brother-in-law, until now my sister-in-law and myself, we cannot see eye to eye. But I mean, that is past. It's just that my question is on the MRTA settlement. When the disease settles, I mean, his insurance settles everything, why is the property not being recognized as his entirely, although there are two names?
Because the properties they are half.
Yeah.
You know? So actually the MRTA is to just cover, you know, the loan of the properties, but then in record the names, you know, there's still two names on the property. So you know, there are no such thing as if you cover the loan, then the property will belong to you solely, because the names, they are registered under both of their names. Yeah. Okay. All right. Are there any?
Good afternoon, Nicole.
Hi.
I have a question. So let's say if we have an asset in overseas, right? Should we include the will written in Malaysia? Is it still valid, or we need to approach that country advisory firm to do it?
For this, thank you for your question. For this, many people also been asking us. So actually, for overseas properties, right, and assets, you can include into your will, in your Malaysia will, just that it serves as a directory. Because if you want to use your Malaysia will to, you know, obtain probate in that country, you have to make sure that, you know, that country is also in the Commonwealth, you know, the society. Only it can work. or else then you have to draw up another will in that country, which we advise you to do so, because different countries, they are governed under different laws. So if you use the Malaysia one, maybe it's not very practical. So yes, you can include in the Malaysia one, just that it goes as a directory to your beneficiaries so that they know, oh, actually Singapore you have properties, or Australia you have this, so they know what to do. Yeah. So, but then we still advise to draw up another will there to cover that assets.
Okay. Thank you.
Any other more questions? Okay, there's one here. I'll just read out the question. My wife from Lim Chi Chia. So my wife renovated her mom's rundown shop lot, and she received her repayment in form of rental in kind. What happens to rental now collected by my wife if her mom passed away? Can her siblings claim, dispute the rental? There is no written agreement as it is based on faith and goodwill. Okay, so meaning to say that your wife's mom did not write a will, right? Mr. Lim, can you just on your mic so we can?
Yes.
Okay, so her mom did not write a will. Okay, so according to the law, actually, the rental collected, it forms part of her mom's estate. So actually, it has to follow the Distribution Act as well to distribute the money. So let's say if your wife's father is still around, and also all her brothers and sisters still around, and I'm not sure whether the parents still around or not. So if they're all around, actually these people, they are entitled to they are entitled to inherit the money, the rental claim from the rental. So actually, if there's no written agreement, so it's harder to prove lah. It's harder to prove that how would you know that actually her mom only want to give the money to your wife. So if there's no proof to prove, so the only way is to follow the Distribution Act, unless there's an agreement saying that okay, all the rental I give it to she will give it to your wife. Okay, so in this case, then you will follow the Distribution Act. Okay. Any more questions? Okay. There's one question from Evelyn. What about some online investment or trading accounts? Can it be included in my will? Malaysia will or my will? I done my will previously in Singapore, and I was advised that I have to do a different will for Singapore properties, assets, and Malaysia. Okay, actually, like I mentioned just now, if you have other properties or investment in other countries, it is advisable for you to write that the will in that country to protect the assets there, because in some situations we are not sure. Maybe if you use Malaysia will, you bring it to Singapore and you want to do resealing and stuff like that, you have a lot of consideration to take into account. Like, is it Commonwealth country? Is it recognizable by the government in Singapore and stuff like that? So to be safe, you can include your Singapore trading stuff, your accounts in your Malaysia will, but then it just serve like a directory so that your beneficiaries, they know that, oh, actually my dad has a my dad has an investment trading accounts, that he has money there. So actually you can locate, I mean, you can locate where is the property at, so you can find it accordingly and such. That's why we always encourage and also advise clients to list it down as detailed as possible, like where, which country and stuff like that. Okay, so that it will not have any conflict lah. And also in between you won't face like, oh, cannot, then I have to, so if you cannot, then you have to apply for LA in Singapore. So there's double process now. One, you apply probate here because you have Malaysia will, but then Singapore is not covered, so you have to do LA there. So you spend on both application in different countries. Okay, so okay, there's another question. What from Annette? What about insurance or savings where we have indicated the distribution in the contract of policy accordingly? Will that be distributed as stated, or the law will again want to follow? Okay, this question we will go into that after lunchtime, because Dato Lee will share on trust, and also we will link to insurance, and also on the nomination part, and also with nomination and without nomination. Then which we will go into detail lah. So after the trust sharing, maybe trust sharing, after that, if you don't understand, we will explain to you further. So because we don't want you to be confused first, this is the will, the sharing on will first. After that, we will share more on the trust, the insurance, and also life planning and stuff like that. Okay, so we don't want to be, we don't want to feed you on too much information at this first part of the sharing. So later on, we will after the lunch, we will come back together and we will continue on our next session on trust and insurance, and also, I mean, how to package, and also how to leverage on insurance to make your planning more complete. Okay, so yes, can and will. Okay, this one we will talk about it later also. Okay, so you don't worry. This we will cover on the next part of our sharing. Okay, so other than this, any more question on wills? Any more, or you would want to share your experience? Some of them, some of you have written views, right? Okay, some for okay, for Anna, I will private message you later. So for the rest, if you have any sharings to share or your personal experience on this area of estate planning, you can just on your mic and we will have some sharing session before we go for lunch. Okay, so I mean, if you can share something you have came across, or your own experience, so we can understand. Like it's very good from Mala, because you share your personal experience, so that more people can, you can see actually this thing does happen, not only not only by word of mouth, or from articles and such. So it is based on true real life cases now. Okay, so if you do have anything to share, feel free to turn on your mic. Okay, just to inform, our next sharing will be 2 p.m. So we will let you guys off for lunchtime. So we will come back, we will resume our sharing at 2 p.m. So remember to come back on time, because we will start on time, and also we wouldn't want you to miss the continuance of the sharing from the will. the will part. Okay, so that's it for the will part. So you will just have a break here, so you guys can go for your lunch. So we will come back again at 2 p.m. Is it okay? All right, so all right. Okay, so we will stop here. So we will see you guys at 2 p.m. All right, we'll be having Dato Lee to share for us. Okay.
Okay, also for the ones who won't be joining after lunch, because some of you said that you have some other things to do, don't worry, because this whole session and class and program is recorded. So if you miss out some of the classes or some of the sessions, you can refer back and play the video back, because we will be sending this recorded video to you after the program. So don't worry, yeah? Okay, so you guys can go for lunch now, and we'll be back at 2 p.m. Okay, thank you.